Welcome back to Gimme Some Truth. I'm Alicia Vande Ven, and I am joined in the booth again today with Notesong Srisopark-Thompson, who is an estate planning attorney. And this will be part 2 of a conversation that we had about estate planning, why it's important for clients and just anybody to have at least a will, if not kind of taking the next steps and really putting together a full estate plan that may include a trust or, guardianship for children and all of those things and why that's so important. Yeah. In part 2, though, we really wanted to dig in a little bit to the differences between a trust, a will, and a beneficiary designation, because those are 3 very different things. Mm-hmm. And I think that both of us have found in our profession that when we're talking with clients, that they don't necessarily understand the differences. Mm-hmm. They may say, well, I have a will and the will says X, but then they have a retirement account and the beneficiary is somebody different than in their will. And they don't understand that those are 2 different things. So I guess I will first ask you is, what are the differences and why would it be advantageous for clients to maybe have a trust that's beyond a will, and when are those used?
Sure, that's a great question. And honestly, that's kind of where I start all of my prospective client meetings is with an estate planning 101. I just kind of get a baseline of what people's knowledge is, because as you mentioned in one of our previous conversations, it really comes down to lack of knowledge in both of our fields. But it's all around probate. And so I asked, do you understand what probate is, or have you heard of it? And people are like, yes or no. But it's about probate. Probate court is a special court that deals with estate planning. They also deal with guardianship, all sorts of other life issues, but particularly probate. And another myth is that if you create a will, customize it, you don't have to go through probate. Not true. All wills have to go through probate. I mean, the one that you create with attorney, very comprehensive, or if you create one on your own at the library, doesn't matter. And the reason for that is because the court needs to make sure that it's valid, legally valid, correct witnesses, that it's drafted correctly, that it has certain parts in it. So it's pretty complex. The statute for that is huge. It's good reading. I like it. But to have an expert help you with that. So probate court, avoid it. Right? People want to avoid probate court. And so not everybody needs a revocable living trust. So most people just say the word trust, but even within that word, there's so many different varieties. So let's go back to a will. A will is one of the oldest legal documents that came over from jolly old England. It still requires a wet ink signature. The courts require an original, very rarely accept copies, because it's such an important document. It's your last will and testament. This is my testament. These people get my stuff. That's huge. So that's why it needs an original. And it's a real hassle if you don't have one. You're in court. And every time you interact with the court, there's a fee. So that's where probate court is kind of like the boogeyman. Because you don't want to pay more money to the courts, nor do you want your kids to go through it.
So then how do you avoid probate court?
There's all sorts of tools that you can use. Depending on your situation, there's a special beneficiary deed that you can use where you can name specific beneficiaries to receive your property, real estate. And by doing a special kind of deed, it goes outside of probate, becomes a non-probate asset. But really, like beneficiary designated assets, those are an important area because a lot of people's assets are definitely in that category that you help with.
Yeah, and I think common ones that, people listening might have is a 401k account,
yep,
or an IRA or a Roth IRA.
Mm-hmm.
All of those accounts have beneficiary designations, and that supersedes what's on your will. So you could say in your will that you're leaving everything to your children, but if the beneficiary designation on your retirement account is your spouse, it doesn't matter what your will says because the beneficiary designation is what's determining where that asset goes.
Right, or maybe it's going to your ex-spouse.
That is another important thing is you may update your will, but if you got married, got divorced, did you update your beneficiary designations on all of your accounts?
Yep, and the company handling the retirement annuity, whatever it is, they don't care. Whatever's on that paper, that's who's getting a check.
Yep.
Or if your kids are 4 and 2, right? Like, well, they can't. I mean, they're going to get this inheritance. Now what? How can I guarantee that they're going to put that towards education or, I don't know, ballet, basketball, whatever you would use the money for your kids. So when you create your own estate planning document, a will, and that's very basic. It's the most basic, least expensive method to making sure that the right people get your things. And again, most importantly, that your kids are being raised by the people that you want to raise them, who have values aligned with yours, and your pets, right? I think, my 2 sheepdogs, not everybody can handle them. So the amazing paralegal who works with me has agreed to be their guardian because they know she's part of the herd. But so the will is very public also. So you've heard of, again, Jolly Old England, they stand on the stairs. Hear ye, so-and-so died. If you believe that you are entitled to an inheritance, step forward. Kind of similar thing still happens. There has to be notice posted in the newspaper, like old-fashioned newspaper, saying so-and-so passed away, to give creditors, anybody that they owed money to, notice that the person died so that they can settle up their bill. And also give notice to beneficiaries because, there's a lot of stories of, I only have 3 children, but actually you have 4. And so that 4th child that wasn't part of your life is still entitled to an inheritance.
Sure.
And they can say, hey, I have a right to an inheritance because I meet the qualification and the definition of child under Wisconsin law.
Sure.
So that happens. Specific things like that. A revocable living trust, on the other hand, is a contract. It's just an agreement. When you say trust, I think of like a vault, which it is. It's like a magical vault, which you can put things into the trust to avoid probate. So that's another method. But there's certain criteria that I look for in the client's personal and financial situation that would qualify them for trust. Ultimately, I'm there at our initial consult meeting to give a recommendation based on the information that they share with me at that time. I think a will-based plan will be just right for you.
Sure.
And again, you can amend your documents, and if you start with a will when you're just starting off your nest egg, that's fine. But down the road, 20 years later, you've done well. Your nest egg has grown, right? Yeah. You can upgrade your documents to a revocable living trust, or just.
So, at what point would you recommend a client upgrade from just having a will to then saying, you know what, I think it's important now that we establish a trust? Sort of, what's the trigger for that?
There's different things I think about. Whoever's creating the trust or whoever's creating their estate plan, I look at their income. I look at their income potential. So certain professions, right? Like they might be dirt poor in school, but then, down the road, after they put in their blood, sweat, and tears for many, many years, physicians, for example, they have really good income potential. And so if you create the vessel, the trust now, then it's ready to go. Like you don't have to have a delay when you get, when you acquire your first home or something like that. But it's a contract, it's private, so nobody gets to see it unless you show it to them. The public doesn't get access to it. You're not held to the deadlines of probate court. You're not held to those fees that have to be paid and the paperwork, and it's a paper chase.
That's interesting because that's one thing that we talked about in our earlier podcast was the cost of working with an estate planning attorney. But I think that one thing that people don't consider is that it could end up costing them to not work with an estate planning attorney, whether that's through, probate court or, your heirs maybe fighting over your assets after you're gone or having to kind of sort through things. That costs money and time. And, maybe for some people, they think, well, what do I care? I'll be dead. But I know most people don't want to make things harder on their family members than they have to be in these types of situations. So it sounds like to avoid probate court, you can establish a trust, and that keeps things out of probate court, keeps things private. Don't have to go through that way. Beneficiary designations. So if you have a beneficiary on a retirement account or a bank account, you can do like a TOD, which is transfer on death for a bank account. Those things then avoid probate. Is there anything else? Any other ways to avoid probate or any other type of assets that can avoid probate?
Well, I mentioned the beneficiary deed if you use a will as your main estate planning vehicle. With a trust, with a revocable living trust as opposed to an irrevocable, I don't like those. I won't draft them unless I absolutely have to, and the situation calls for it. There are sometimes reasons for an irrevocable living trust, but a revocable living trust, the revocable part of it is that you can put things into the trust to protect it from probate, but you can also revoke it. You can unwind it, take it out, and so that's gives you lots of flexibility. The living part of it is that that document is effective immediately once you sign it, once you execute it. And we have our trust notarized to make it more official because financial institutions want to make sure that's an official document. So you often ask for evidence of this trust and when it was executed. So the trust is just I would say it's a more complex document, but it's the difference between very basic instructions and putting together like a table or a dresser and more complex instructions that's going to make sure it's not going to fall apart.
Okay.
So, and you get to customize it more. So I think of like Candyland. I'm sorry. I was a pediatric nurse. So, right. Explaining an IV to a 4-year-old is like doing that with estate planning. So with a trust, it's like the land of estate planning and trust is your oyster. You can customize it down to, I only want money from my kids' trust to go towards ballet, which my daughter would be very angry about. But anyway, you can customize it really down to certain things. And you can create the subtrust, which plays into financial planning because, again, who you name on the beneficiary designated assets, that's who it's going to go to, and the method. Sometimes you want to name the trust, sometimes you don't.
Yeah.
So,
well, I think the other part that we see on our side of it is clients will go through the effort to work with an estate planning attorney to create a trust. They'll do all the things that they're supposed to do, create all the documents, and then they stop.
Yep.
And they don't fund the trust. They don't update the beneficiaries on their accounts so that assets go into the trust.
Right.
They don't update whether it's their home in the name of the trust or any investment accounts in the name of the trust. So if you go through all of this effort to create a trust, but then never actually put any assets into the trust, then it doesn't really do you any good. And part of our job is we are often encouraging clients, get us those trust documents, get us those funding instructions. We will help you retitle those accounts, retitle those assets so that you're actually funding that trust and that you didn't pay all that money and go through all that work to draft a document that now you're not using.
Well, here it is. I mean, you might get a beautiful trust created and it's so nicely executed and they have a big embossment by the notary. But if you don't fund it or fill it, I also say fill it. I'm very visual. You have to fill your trust in order for it to be working. If you don't do that, it's just expensive legal documents. That's it.
Yep.
Right? Then all your hard work in creating it is all for naught. And I think of trust, if my clients go through a revocable trust plan, if they go with that, I say it happens in 2 phases. Phase 1 is the really heavy lift. You got to think about all the hard questions. So I always recommend, hey, pick a Friday night, like have your favorite tea or maybe your favorite old fashioned. Because the questions are very emotionally charged. But you got to sit down and do it. So that's a big piece of it. But funding, that's phase 2. So after you execute your documents, you're like, woo, congratulations. You have an estate plan. Phase 2 is when we start to transfer the baton over to financial advisor, hopefully, if they're working with one, or to give them instructions on how to connect with a company to redesignate the beneficiaries on the retirement plan, the annuities. But, you also want to have liquidity, which means you want to have a little bit of extra money to pay for any unexpected bills. And there's so much to think about, but that's why you hire both of us, right? I mean,
we work together.
Yes.
And we kind of give clients to the estate planning attorney and then they work with them, draft all the documents, and then they kind of send them back to us and we help implement it. So it's very much a teamwork approach.
Right.
And I mean, that can be true sometimes for accountants as well. So sometimes people have used the analogy that they say financial planners are like the quarterback.
Oh, yeah.
And we're sort of directing the different pieces of a client's team.
Okay.
And sometimes that it includes an estate planning attorney or an accountant or other professionals that sort of help kind of make up that person's team.
Like that. Yeah. And I'm like, in my head, I'm like, I don't understand football, but I kind of understand basketball. And it's like the point guard.
Yeah.
Yeah.
When I'm using a sports
I don't
analogy,
know.
and that's,
I really don't know. Yeah, that's good though. But I love that. It's a team effort.
It is. It very much is. It very much is. Well, we really appreciate you coming in and answering all these questions, and hopefully, clients are walking away with a little bit more knowledge than they had before. And I'm sure this won't be the last time that we have you. So thank you again for coming on this another episode of Gimme Some Truth.
Well, thanks for having me.
Walkner Condon Financial Advisors is a registered investment advisor with the SEC. Registration with the SEC does not imply a certain level of skill or training. The opinions expressed by the participants of this podcast are their own and do not reflect the opinions of Walkner Condon Financial Advisors. All statements and opinions expressed are based upon information considered reliable, although it should not be relied upon as such. Any statements or opinions are subject to change without notice. Information presented is for educational purposes only and does not intend to make an offer or solicitation for the sale or purchase of any specific securities, investments, or investment strategies. Investments involve risk and, unless otherwise stated, are not guaranteed. Information expressed does not take into account your specific situation or objectives and is not intended as recommendations appropriate for any individual. Listeners are encouraged to seek advice from a qualified tax, legal, or investment advisor to determine whether any information presented may be suitable for their specific situation. Past performance is not indicative of future performance. Thanks for listening, and for further information, please visit WalknerCondon.com.